see who we got here. Everybody but Claudia, I think.
Good morning.
How are y'all? We have in the waiting room. Claudia. Waiting for Claudia right now. Court reporter. There she is. You all have everybody?
Yes, Judge.
All right. All right, this is 00385-905-2020. It's the state of Texas versus Philip Murray Perez. And we're here today on I'm assuming it's a motion to hold bond in suspicion, is that right?
Yes, Your Honor.
And the record should reflect that we're doing this by Zoom, and Mr. Perez is online with his attorney, who's also online. You may either make an opening statement or call your first witness.
Judge, before we get started, I think we can probably pre-admit some exhibits. So I'm going to offer States Exhibit 1 through 5. I did speak with Lance before this, and there is one reading in States Exhibit 5 that he's not stipulating to, but I think with that, we can agree to pre-admit those. Lance?
Yes, Judge, that's correct. The only thing that I'm not able to stipulate to is the exact alleged alcohol reading on States Exhibit 5.
Okay. Those 5 exhibits will be admitted then, with the understanding that there's a argument about that one, the credibility of that one reading, I guess. Okay.
And I think everybody should have copies of the exhibits. Is it okay if I don't do screen sharing and we all just look at our respective copies?
Fine with me.
Fine with me.
Okay. Then the state calls Lisa Mendoza.
If you would raise your right hand and be sworn. You swear or affirm testimony about to give you the truth, the whole truth, nothing but the truth, so help you God.
I do.
All right.
Lisa, will you state and spell your name for the record, please?
Yes, my name is Lisa Mendoza, Lisa, last name Mendoza.
And how are you employed?
I'm employed with probation department as a pretrial supervision officer caseworker.
Are you a pretrial supervision officer for Philip Perez?
I am.
When was he placed on pretrial supervision?
He was placed on pretrial supervision on April the 24th of 2019. I'm sorry, 2020.
For what offense?
The offense is a DWI second.
While on pretrial supervision, is Mr. Perez to complete certain conditions or refrain from doing certain things?
He is.
Will you run through some of those conditions?
Yes, basically the conditions state that he is not allowed to consume alcohol. He is required to report on a monthly basis as required. If he has any positive alcohol readings, he is required to retest within 5 minutes apart twice And that is just for the client or the defendant to provide proof that they weren't actually consuming alcohol.
And is he supposed to have an interlock device on his vehicle?
Yes, that is correct.
Did you explain all these conditions to Mr. Perez?
I did. He actually reported to our office on May the 4th. He filled out some paperwork. We did not meet that day. Because of COVID, we did have a phone interview. And prior to that interview, I emailed all the documentation that I went over with him over the phone, which includes his conditions of bond.
After May, did Mr. Perez report, at least initially?
He did.
At some point, did he stop reporting?
He did stop reporting. He didn't report for July, August, and September.
Also in September, were you notified of a potential issue with his interlock device?
It actually occurred. Are you talking about the violation he had or just issues?
Was it did he get locked out of his interlock at any point?
He did. He got locked out of his device on September the 14th, and he was locked out for 16 days.
Okay. What did you do in response to Mr. Perez not reporting and that lockout notice?
I contacted him via email. He responded to my email. He actually sent me 2 emails. On September the 21st, I actually mentioned to him that I'm resending a second email and I needed to get 2 monthly report forms, one for August and one for September. On September the 2nd, he actually stated that I never sent it to him. So that's when I responded on September the 21st. I sent him a copy of the email and then 2 monthly report forms.
And to clarify for the record, these emails have been admitted as State's Exhibit 1. And Lisa, did I send that to you in advance of this hearing for you to review as well?
You sent me Exhibit 1 and Exhibit 2.
Okay. In his first response to you on September 24th, what did the defendant tell you?
He said his vehicle had not been running, which is why he missed his calibration appointment. He said his future mother-in-law has been in the hospital, which was his main responsibility as she resides with them. He said paperwork for August and September was filled out but mailed by a family member. They forgot, and he said he was disappointed and furious. And then he said in August he didn't hear from me, nor did he receive any paperwork, which is when I had responded with a copy of the email. And then he said his vehicle was being repaired.
Did he mention having liver disease in that email?
He actually sent me a doctor's notice.
But just looking at that September 24th, the first email, after he said, "I do not work because I'm on disability."
I'm sorry, let me get that.
It's on page 2 of State's Exhibit 1, if that helps at the top.
Okay, yeah, is this where okay, so he says he reread what he wrote and he realized that he made a mistake.
So if you'll go down to the second page.
Okay, let's see, I was reading that. Okay, I'm sorry, I don't see that on the second page.
Okay, let me share my screen real quick. Let's see if I can make this work. Okay, can you see my screen?
Yes.
Okay, this is State's Exhibit 1, page 2. looking here where it says, "Good day, Lisa," coming down to, "I do not work because I'm on disability." What did he tell you about liver disease?
Yes, he said he had liver disease. He doesn't drink, but he had a slip up in April and it's costing him dearly.
Okay. After this first email, did he send you a follow-up email?
Yes.
Okay, and I have it shared on my screen, States Exhibit 1, so you can refer to it there. What did he tell you in that second email on September 24th?
He said, "Hi, Lisa. I've reread what I wrote and realized that I made a mistake when I said that I do not drink." He says, "What I meant was that I do not drink and drive, which I have not driven lately due to my Texas driver's license suspension. My attorney is working on resolving this matter. I do have an alcoholic beverage occasionally around the house, which is legal. But when I do begin driving again, I will be much more careful. Thank you again and have a pleasant day."
Okay, and what did you do in response when he told you that he has a drink at home, which is legal?
I responded and said, "No, Philip, you cannot drink at home at all while you are under these bond conditions because of your DWI. That was explained to you in great detail. You are in violation of your bond order, and I still haven't received your monthly report form for July, August, and September." And I asked him to please fill out those forms for me.
Did he eventually send you those forms for those
He
3
did.
months?
He did.
And what did he include in that when he mailed those to you? What did he include in that?
I'm sorry. Let's see. I got this.
Here, let me rephrase. Did he send you a letter about kind of his situation along with that?
Yes, I got a letter. Let me pull my paperwork. I got a letter, a doctor's note, stating that he has a terminal illness. He is on disability, which that's all I got from him, including the monthly report forms.
Did he also send you States Exhibit 2, which I'm now sharing on my screen?
That was, yes, he did. I'm sorry. That was a letter. He said, "Enclosed is my paperwork for July, August, and September. I assume I will be receiving my paperwork for October. My car has been repaired. It's been calibrated."
Lisa, sorry to interrupt. I don't want you to have to read all of that, but what was
Okay.
kind of the gist of, did he admit to drinking in this letter?
Yes, he did.
On what dates?
He admitted to drinking on July 12th, July 10th, and September the 16th.
Okay. And are all of those violations of his bond conditions not to consume any alcohol?
That is correct.
Okay. Did he also tell you that his attorney was still working on his license suspension?
Yes.
And then at the end, did he tell you that he was going to be compliant going forward?
That is correct.
Okay. Was he compliant going forward?
I have not received any contact from him since this violation was posted. I've not received any phone calls or emails.
And when you refer to a violation, what are you referring to?
As far as violations, violations not reporting, being into lockout, and having a positive alcohol reading on his device.
When was that positive alcohol reading?
He had an alcohol reading on October the 12th at 3:33 p.m. He had a high alcohol reading of 0.088. And as instructed on the bond conditions, he should have retested twice, and he provided no retest.
Okay, so after that October 1st letter where he said, "I'm going to be compliant going forward," was he?
No.
All right, thank you, Ms. Mendoza. We pass the witness.
Mr. Evans, do you have any questions?
Just briefly, Your Honor. Ms. Mendoza, certainly we've heard your concerns and the allegations of violations that you just went over with, but you would agree with me, wouldn't you, that in State's Exhibit 1 and especially in State's Exhibit 2, the flip side regarding Mr. Perez is that he's very forthcoming. He does not appear to be hiding information from you, basically admitting the bond violations in that letter, correct?
That is correct.
And regarding your testimony about failing to stay in touch after the allegations of violation were forwarded to the court, that would have been after October 12th, correct?
Yes, that is correct.
Because that included the October 12th allegation with the interlock device, correct?
Yes, that is correct.
And to your knowledge, Mr. Perez would have been notified that there was a bond violation that was going to be considered by the court. Is that right?
He would have been notified by the court or by you.
Correct. And it would be understandable if at that point, especially after being notified that this action might be taken, and a normal person would want to contact their attorney, correct?
That is correct.
It would not be unusual for that person to be under the impression that the court matter had to be dealt with before continuing on with the bond caseload, if there was a question as to whether bond might even be held insufficient, correct?
Object, speculation as to what Mr. Perez might have thought.
Sustain.
That wasn't my question. I'll move on. Actually, I have no more questions.
Anything else from the state? with this
Nothing
witness?
further.
Is Ms. Mendoza free to go?
Yes, Your Honor.
All right,
Honor.
you can check out if you want to.
Okay, all right, thank you.
Call your next witness.
State calls Maria Guerrero.
If you would, raise your right hand and be sworn. You swear or affirm testimony about to give be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Maria, will you please state and spell your name for the record?
Maria, M-A-R-I-A, Guerrero, G-U-E-R-R-E-R-O,
How are you employed?
through Lifesaver, the judicial liaison.
How long have you held that? How long have you worked for Lifesaver total?
Years.
Was that 6 years?
Yeah, 6 years.
Okay. Will you go over your qualifications and your training during your time at Lifesaver?
I've been to do log interpretations for reporting for the ignition and interlock devices and for the portable device as well.
Are you familiar with how interlock devices work?
Yes, ma'am.
And in your experience, are interlock devices reliable methods of detecting alcohol?
Yes.
Does Mr. Philip Perez have an interlock device on his vehicle that is serviced by Lifesaver?
Yes.
Now, in advance of this hearing, did I send you States Exhibit 3, 4, and 5 for you to review?
Yes.
Okay, just so you know, and for the record, those 3 exhibits have already been admitted, so the court has them. On States Exhibit 3, do you have that in front of you, Ms. Guerrero, or do I need to pull it up?
I haven't.
Okay. Will you walk us through States Exhibit 3?
So it's an ignition interlock lockout notice, and that's to notify the officer that the defendant has been on lockout. What that means, the defendant cannot operate the vehicle until he comes back and calibrates the device.
Okay, so at the top, we have client information, then we have service center information. What is the service due date that we see on States Exhibit 3?
9/11.
Okay, what was Mr. Perez supposed to do on 9/11?
He was supposed to come in and calibrate on 9/11.
Okay, and because he didn't come in and calibrate, what happened?
He was put on lockout on 9/14.
Do you know how long his vehicle remained on lockout?
Until 9:30 when he came in.
And you said that during that time, when the interlock is on lockout, his vehicle is inoperable?
Correct.
Okay. Moving to States Exhibit 4, we again have the same client information, service center information. Is that correct?
Yes.
What about reporting information? What reporting period was this report for?
Reporting period from 8:14 to 9:30.
Okay. And how many times did he start and stop his engine during this period?
4 times.
Now I see there were 2 illegal starts. What is an illegal start?
It's when the vehicle is being high jump with the battery, or when the defendant's trying to start the vehicle illegally.
Okay. Does the interlock device do anything when there is an illegal start?
It detects it and it will be flagged on the report as an illegal start.
Is the operator of the vehicle notified or given any kind of code or anything?
For an override code, that's to bring the vehicle back in, what we call an override code. So they do call our 800 number, they get an override code, it gets put into the system, and the vehicle cannot be turned off during that time. It's enough time for them to get to the shop and get the device calibrated.
Moving to State's Exhibit 5, what reporting period does State's Exhibit 5 cover?
9:30 to 10:14, 2020.
Okay. And there were 19 engine starts and stops during that period?
Yes, ma'am.
Okay. And I think we also see there was a high BAC and then 1 rolling retest refuse. Is that correct?
Yes.
Okay. Going to the second page of State's Exhibit 5, on October 2nd at about 3:10, what does that violation retest refused mean?
It's a rolling retest. Once the vehicle has been started, the device will prompt the defendant to do a rolling retest. And there was a rolling retest refusal at that time.
Okay. And then going to the third page of State's Exhibit 5, on October 12th at 3:33 p.m., what happened?
We have a high rack of a 0.088.
Okay. What does undetermined below that mean?
We can't determine the alcohol since there's no follow-up sample.
Okay.
The vehicle, we didn't receive a follow-up sample from after 3:33 with 17 seconds.
Would he have been prompted to give a follow-up sample after this high BAC reading?
Yes, they are instructed as well. They watch a training video where they're instructed to go ahead and retest.
Okay. And so since you were able to, it's undetermined, does that mean he did not retest?
Correct.
All right. Pass the witness.
Any questions?
Just briefly, Ms. Guerrero, I'm sorry, I probably wasn't listening as close as I should be. You answered a question about what undetermined meant. Could you tell me that again, please?
We're not able to determine because we don't have a follow-up sample provided.
Not able to determine.
The alcohol. We need a follow-up sample after the 0.088.
Okay. All right. So back to State's Exhibit 3. There was a lockout, and I think you stated that was, tell me the dates again of the lockout.
It was on the notification was sent on 9/14. He failed to come into his appointment on 9/11.
Gotcha. And that would be consistent with his statements that the car was not working and it was not drivable, correct?
I will need to look on the client's log to see what was said on basically on the information if he called our 800 number.
Gotcha. So let's turn our attention back to State's Exhibit 4. For that period, the reporting period was almost 6 weeks, August the 14th to September the 30th, correct?
Yes, sir.
And in that time, there were 4 engine starts, correct?
Yes, sir.
And that would be consistent with an automobile that was not working or not driven for that length of time, wouldn't it?
Yes.
And illegal starts, that tells you that, well, there's no way for you to know just how this supposed illegal start was, what methodology was used, correct?
No, we've seen those being flagged basically when the battery's trying to be jumped or having like cables. We've seen that, and the device will detect an illegal start or trying to start the vehicle illegally without blowing into the device.
Gotcha. So it could be somebody that's trying to get around the device. That's one explanation, right?
Yes.
But another explanation could be, for instance, if a mobile mechanic came out to Mr. Perez's house and was working on the car trying to get it started, couldn't it?
We do offer the mechanic's affidavit, which we instructed the clients, if the mechanic's working on the vehicle, please have them call the 800 number. That way it doesn't flag the illegal starts. They get a passcode and it will not flag the illegal starts.
I understand, but there's nothing in State's Exhibit 4 that says that happened, correct?
No.
And that wasn't really my question. The question was, that could be one explanation for an illegal start, would be a mechanic working on the car, correct?
Correct.
Okay. I pass the witness.
Anything else from this witness?
Nothing further. May she be excused?
Yes, thank you.
Yeah.
Call your next witness.
State has no further witnesses. We rest.
And does the defense have any witnesses?
No, Judge, just a closing statement.
Okay. Both sides close.
Close.
State closes.
Any argument?
I'll reserve.
Okay. Judge, I want to make it abundantly clear that Mr. Perez is not trying to pretend like this is not an issue. He understands fully that the court is concerned about these allegations. He was very forthcoming in his emails and letters to the probation officer that are introduced into evidence before you, and admitted drinking. That's not a good thing, but I will tell you that I think his honesty about that is a good thing. I think there's no question, based on the lack of number of starts, that in fact his car was not working. And I think generally, even with the last exhibit, there's a low number of starts. And so that would indicate that he's just not really driving that much. Really, Judge, the reason that we're here today is not to avoid consequences. I would just ask for the proper consequence. And that is, I think that the court's concern about there not being any further law violations and about protecting the community can be successfully addressed, not by declaring the bond insufficient, but by just addressing the root of any perceived problems. Now, number one, I would argue that Mr. Perez Mr. Perez, I will tell you, is very willing to follow whatever the court decides to do in this particular matter today. You will find him very accommodating in that. He knows the severity of this situation. Basically, he told me he didn't sleep last night. He's very concerned about this and wants to make sure that you understand that he's willing to follow the rules, but whatever you decide to do today. But let me wrap this up by saying, the state and I came close to coming to an agreement on the proper remedy to this situation. The state had talked about the possibility of a scram unit. I was concerned about the cost of the scram unit. Finances are a factor for Mr. Perez. And I was also concerned, quite frankly, about the cost of having two different devices that he would have to pay for. Mr. Perez is willing to sign an affidavit that he will not drive. I did not want him to have to pay for both a scram and an interlock at the same time. I'd rather it be an either or. And to try and address the state's concerns and yet also not impact Mr. Perez too much financially, I had suggested, and I'll suggest today, that he be required to have an in-home alcohol monitor that would serve the purpose of making sure that Mr. Perez is not drinking at home in violation of bond conditions. And it would also, I think, alleviate any concern about driving as well, because if he were to leave the house, he has to take that in-home monitor with him in case it asks for a test. I think the in-home monitor would be as effective or more effective than a scram unit. Either way, and especially with a scram, you've got to wait until the unit is taken back in or get the data downloaded to see if there's been any potential violation. So we're not asking for nothing to happen. We just want the sanctions tailored to Mr. Perez's situation. If there are other concerns, I mean, I know that unfortunately COVID is an issue with all of this, but I also know that groups like Alcoholics Anonymous are meeting virtually online, things like that. If there's some things like that the court feels would be appropriate in this situation, we're certainly willing to to do what we need to do in that regard. So in sum, Judge, we would just ask that a solution that would assure the court that there'll be no further violations and yet not have a devastating financial impact on Mr. Perez be considered.
Your Honor, I agree. I do think Alcoholics Anonymous would be a good option for Mr. Perez, especially given the letter that he sent on October 1st. It appears he does drink on anniversaries of difficult life events, so maybe coping mechanisms that he can learn in AA would be helpful. We are going to request a scram and that the DLD remain on the car, and here's why. We clearly need to keep closer tabs on Mr. Perez and his drinking. That is why we're requesting the scram. But why a scram versus in-home? I'm concerned, given that Mr. Perez told his pretrial supervision officer that he could drink at home because it was legal. I'm afraid that's going to translate out of the home. So while he thinks it's legal to have a glass of wine at dinner or at a friend's house or on the tennis courts, wherever he chooses, that monitor needs to be on him at all times. And that's why a scram is more appropriate here. And we need to keep the interlock device on his vehicle. What a scram or in-home unit cannot do, as you're aware, is it cannot shut down the car. On October 12th, the interlock did exactly what it's supposed to do. When he got behind the wheel and it detected alcohol, it shut down the car. And that's why we need to keep it on. I'll also point out that in State's Exhibit 1, he told Lisa Mendoza that he wasn't driving, but in State's Exhibit 4, there were at least 4 starts. Perhaps the mechanic was working on it twice, but there still are 2 other starts. So I do believe he will continue to drive. He's expressed in those emails that his attorney's working on his suspension, and I believe he wants to continue driving. So that interlock needs to stay on his vehicle.
Judge, may I respond briefly?
Yes.
For clarity? Mr. Perez is absolutely willing to not only have the in-home unit, but also to sign and file with the court an affidavit stating that he will not be driving.
Well, I think at this point, because of the past conduct, I am going to add the scram to a condition of his bond, and he is going to be required to attend 2 AA meetings a month or a week. I think it's going to help him. Obviously, this case has been filed, and so if y'all want to resolve it at some point, that could change all the conditions. But the bond conditions right now, he's going to have a deep lung device on his car, and he's going to have a scram unit on him. He's going to be attending AA twice a week. Okay.
Judge,
I'm going to leave the amount of the bond as it is.
the only question I have, and this may be better for the probation department, is is there any assistance if people are financially unable to meet that economic burden of paying both?
I don't know. You would have to talk to probation about that. They may have some form that he could fill out saying he needs help with that. And, he'll have 2 weeks to get it installed. So.
Okay.
All right. Good luck. Thank y'all.
Thank you, Your Honor.
Thanks, Judge.